The following program was produced at Stetson University College of Law.
Hi, my name is Steve Dale, and I'm a NAELA member in Northern California. And today I want to talk about coordinating attendant care and available resources. First, I'm going to start talking about hiring caregivers and some common issues that come up. One of the issues I deal with oftentimes when I'm dealing with somebody with a disability, especially when I'm dealing with folks with MS, is we often are dealing with attendant care issues. So I want to talk a little bit about agency and non-agency caregivers. Persons with MS and their families frequently engage caregivers from outside the home to assist in their care and provide respite for the family. Caregivers may be found through agencies in which payments to the agency cover wages, taxes, insurance, and benefits the agency provides to the attendant. If you hire an individual who is not from an agency, there must be a determination about whether or not they are an employee or an independent contractor, according to the IRS publication 926 called Household Employers Tax Guide. Now, I've given you the website to find this, which is www.irs.gov/publications/P926. And I would really encourage you to download this publication. Well, let's walk through a little bit of what it says. The determination of whether a caregiver is an independent contractor who's going to be responsible for paying his or her own taxes, or an employee for whom the employer must withhold and pay unemployment and income taxes will depend on several factors. And the thing about this is that there isn't one single factor. You have to look at all the factors. So let's walk through that. Factors include the right of control by the employer over details of the work, whether the employee is engaged in a distinct licensed occupation or business, whether the employer supplies the tools and place of work for the caregiver, the length of time for which the person is employed, whether the employer can discharge the worker, whether they are paid by the time worked or by the job, and whether the work is part of the regular business of the employer. Now, if the individual caregiver tells you they are registered as a business with the federal and state government, it's wise to get verification. Ask the individual for their employer identification number, and it's going to have 2 numbers with a dash followed by 7 numbers. That's a dead giveaway. If they don't have one, or if they do have one, you don't have to withhold taxes. Now, if all they have is a Social Security number, which is 3 numbers followed by 2 numbers followed by 4 numbers, you are liable for withholding and filing taxes and all statutory benefits. So let's go through some examples of household employees. You pay Betty to babysit your child and do light housekeeping work 4 days a week in your home. Betty follows your specific instructions about household and child care duties. You provide the household equipment and supplies that Betty needs to do her work. In this case, Betty is your household employee. Let's go through an example where somebody is not a household employee. You made an arrangement with John to care for your lawn. John runs a lawn care business and offers his services to the general public. John provides his own tools and supplies. John hires and pays help he needs. Neither John nor his employees are your household employees. Now, I'll just give you a clue. There is no such thing as an independent contractor unless they are registered with the business. If you are paying someone to provide care for you, they are your employee unless they, once again, have their own business or a member of an agency. The example I like to give is that, consider the roofer. You may have hired him as an independent contractor, but sometime between the time he falls off the roof and hits the ground, he becomes an employee, and that's where the liability begins. So who cares? Well, if you hire an individual caregiver directly, federal law states that they are your employee and you must pay their statutory benefits as you would for any employee. This also includes household withholdings and filing Medicare, state and federal unemployment, and Social Security taxes. If the caregiver is injured on the job, the employer could be liable for the worker's injuries. And I will tell you, the incidence of caregivers injuring themselves is oftentimes astronomical, and this is one of those risks you don't want to take. If the caregiver has not met his or her tax obligations, the responsibility falls on the employer. The employer could be liable for interest on back taxes, civil fines, and the possibility of criminal penalties. I have, as an attorney, counseling many folks with MS. Unfortunately, I've had several situations where my clients did not take my advice, and I had in one case somebody who ended up having to pay over $25,000 in fines. That makes it a very bad day. So, let's go through one other factor that often comes up when we're talking about providing for care. And as I go through this, I'm going to go through some generalities because much of what we're going to talk about is very state specific. I know for myself, oftentimes that when I meet with my clients who have MS, one of the biggest expenses they have is caregiving. And now, of course, everyone is on a different track, but this is a very common issue. So with this, many times there are programs under Medicaid in your state that may be providing attendant care services. Persons with MS that need attendant care may qualify for assistance by qualifying for Medicaid. Eligibility criteria vary state by state, subject to certain federal minimum requirements. So the rules are similar, but oftentimes they'll be very different in different states. Eligibility for Medicaid can be obtained by any number of ways. One way is to do a spend down, which is basically spending your funds down until you meet the financial eligibility. Now, for myself, oftentimes I think it's best not to go this route because you really don't want to get down to the last dollar before you start trying to qualify for these programs. And this is why oftentimes it's good to plan on eventually possibly qualifying for Medicaid if that fits your situation. Making certain transfers of assets are allowed on a state-by-state basis. Once again, one should not do that without working with a qualified NAELA attorney who understands the rules in your state. Or transferring excess resources in what's called a self-settled special needs trust. I'm not going to go through that today because I think that's been covered in other videos, but this is something that, once again, you should only do with a qualified NAELA attorney. One really good website to get information about medical services, and especially about services in your community, is the Kaiser Foundation website. And I've listed the site for the website on this page. And on this website, you can find what the rules are in your state. So, with these programs, there are many kinds of programs, and one of the programs that I often use with some of my clients are what are called the working disabled programs. Many states have programs to support persons with disabling conditions who desire to secure employment and live in the community and have higher incomes. And there are ways that you could buy into Medicaid coverage by paying a monthly premium. Now, a warning through this segment, I'm going to go through California's Working Disabled program, so the program you have in a different state may be very different. So let's go through what we call the 250% solution, and this is based on a program called the Medicaid 250% Working Disabled program. Paula has MS and needs attendant care. She's been rapidly running through her assets. She owns a house and an IRA worth $200,000. She applies for Medi-Cal, which is our Medicaid program, and in-home support services, which is our attendant program, but is turned down because she has too many resources. The 250% Working Disabled program may allow qualifications for Medi-Cal by paying a monthly premium. To qualify, she must meet the medical requirements of Social Security definition of disability, be working and earning income at least part-time. Now, in California, and I think this is true in many states, even working and earning $20 a month qualifies you for this program. And I've done this many times working with clients where what we're trying to do is have them not have to spend down their retirement plan, be able to keep that intact, and this is a perfect program for this. I also have many folks with MS that are using this program, and they're probably working part-time here, and the attendant care and the assistance they get allows them to be able to take care of their day-to-day needs. Having countable income less than the 250% federal poverty level is also required. And disability income is not counted for the 250 program. So other things that are not counted are things like workers' compensation payments, state disability payments from insurance, state, or private disability benefits. They are also not included. They must have assets worth less than $2,000 for an individual or $3,000 for a couple. The resource limitations are very similar to SSI and Medicaid in most states, with a big exception that retirement funds like IRAs are not counted as assets for this program. And once again, this can be a very valuable tool if you have something similar in your state. Now, the way it works in California, just to show you the example, is monthly countable income limits for this program are $2,257 for individuals, and premium payments range from $20 to $250. And you can see, once again, in the table I've provided you, how this is graduated. Warning, this example is from California. So your state is likely to have a similar program, but it's going to be different. Consult your local NAELA member for specifics on programs in your state. Now, one other thing just to mention, with the ACA or Obamacare, we're looking at new programs on top of all these and new options. And this is part of working with a knowledgeable elder law or special needs attorney that works with NAELA, is that oftentimes, and this is one of the values of being a member of NAELA, is it helps me keep up to date with the program so I can better serve my clients. The Affordable Care Act includes a number of programs and funding improvements to help ensure that people can receive long-term care services and supports for their home or the community. The law improves existing tools and creates new options and financial incentives for states to provide home and community-based services and supports. Now, the good news is there are more and more options. The bad news is that, once again, these are changing all the time, and it takes somebody who is very knowledgeable in this to keep up with all the options so you can find just the right option for you. Areas that the ACA covers, and I'm not going to go through all of these here in detail, but are things like the Home and Community-Based Services State Plan option, the Community First Choice option, the State Balancing Incentive Payments Program, Money Follows the Person Program, and many demonstration projects for testing the experience and functional assessment tools. So, in conclusion, what I'd just like you to remember is that attendant care programs and laws vary greatly from state to state. Programs are changing, and it's important to keep up to date with new programs. And to learn more, consult with your local MS chapter as well as your local NAELA member. Another thing I'd like to mention too, by the way, is one of the reasons why we need to support the National MS Society is that many of these programs that can be implemented in the state happen because of the advocacy of organizations like the MS Society. So once again, this is an area that's constantly changing. My experience has been that attendant care becomes a big issue to focus on. It's better to plan ahead rather than wait for the crisis. I want to thank you very much.